you. Good morning, everybody. We have a title of a panel, Cold Case. So if this panel does well, we will be in syndication by the fall television season. You're very fortunate this morning to have three very distinguished presenters on this issue. I'm going to introduce them very briefly. They are going to move through their presentations, and then we want to have more of an interactive discussion at the end, and they're all looking forward to that. Norm Gahn is an assistant district attorney with the Milwaukee District Attorney's Office, and he has been there since 1984. He's lectured extensively around the country on the use of DNA evidence in the courtroom. He is a member of the DNA Legal Assistance Advisory Group of APRI, and he's been recognized by NIJ as an innovator in the field of DNA evidence. Jules Epstein is Associate Professor of Law at Widener Law School. He teaches evidence in criminal law. He is counsel at Carey's, Radofsky, Messing, and Feinberg in Philadelphia, where he works on criminal defense appeals and post-conviction matters. He teaches advanced evidence and capital case litigation courses for the National Judicial College. Professor Epstein was a member of the National Institute of Justice Work Group on Forensic DNA for Officers of the Court. He is a member of the Pennsylvania Commission examining the causes of wrongful convictions. And our wrap-up presenter will look at this issue from the victim's perspective. Mary Lou Leary is Executive Director of the National Center for Victims of Crime, which is the nation's leading resource and advocacy organization for crime victims. Ms. Leary has served in a variety of positions in the United States Attorney's Office for the District of Columbia that included extensive trial and grand jury experience. She also served in the United States Department of Justice as the Acting Assistant Attorney General for the Office of Justice Programs, Deputy Associate Attorney General for the Office of the Associate Attorney General, and Acting Director of the Office of Community-Oriented Policing Service. I'll turn first to Norm, and they'll move through their presentations. We look forward to your discussion. Thank you.
Good morning. I would like to thank the conference coordinators and NIJ for inviting me to come and present. It's always such a nice compliment when you're asked to come and present in front of your peers, and I appreciate that. And I also appreciate having these last two beautiful spring mornings down here. Coming from Wisconsin, this is just beautiful in the morning and take my walks. Back in 2001, we had a pretty massive new legislation driven by DNA put through in Wisconsin. We put through our post-conviction DNA statute, and there were a number of other changes that we made to our statutory scheme. One of the things where I saw some parallels for the prosecutors and the Innocence Project cases was in the time limitations. Our statute in Wisconsin for post-conviction motion basically removed any time limitations. They can bring those motions and are not restricted by the time. As a prosecutor, we also felt that we should not be restricted by time limitations in the cases that we would like to charge and prosecute. And there were two ways that we've done that in Wisconsin. One was legislatively for our first-degree and second-degree sexual assaults, where we've basically done away with statute limitations in those cases when you have DNA evidence. But also we liberally use John Doe warrants, especially in Milwaukee County, to preserve jurisdiction and issue that criminal complaint and warrant for arrest prior to the expiration of the statute limitations. In Wisconsin, this would be an example of the caption of this is John Doe number 21, and you just put in the alleles, the genetic marker and the alleles at that location. As you can see below the caption, we issue John Doe warrants for robbery. We do it for sexual assault third degree. Our legislative changes only accounted for first and second degree sexual assault. We do them for burglary, you can see, and we also do them for misdemeanors. And it's been very interesting when we get these cold hits well after the statute of limitations on cases that we have, preserved that jurisdiction. We have 2 appellate court decisions in Wisconsin upholding the use of John Doe warrants. Basically, the appellate courts have ruled that the DNA profile is a proper description, and it describes a person with particularity, and also the issuance of it prior to the expiration of the statute of limitations that commences the prosecution. So with those favorable decisions, we also oftentimes run into cases where the statute of limitations has expired, or for some reason we can't charge the case. The victim is left, the victim is uncooperative, but we still complete that investigation in Milwaukee County. We finish it all up. I ask the crime lab to do the confirmation sample. We go up to the prison and talk to the individual. And we make a nice package and send that to the parole board. And the parole board has been very pleased with getting that additional information. Although we couldn't charge it, we basically give a complete case that's been fully investigated with a DNA match showing that this offender, this prisoner, also committed this one. And we do that for purposes of potential other acts evidence and also maybe the basis for sex predator. So again, we believe this DNA is truly a gift. It's a true gift to us, and we should use it and use it aggressively as prosecutors. I'd like to tell you a little bit about a trial I just finished last summer, and it was our John Doe number 5. And back in 1994 and early 1995, we had an individual was attacking women and at gunpoint, dragging them off the street to a secluded area, and sexually assaulting them. It was a vaginal and oral assault. And the description of the individual was remarkably similar that each of the victims gave. And each of the victims were taken to the Sexual Assault Treatment Center in Milwaukee, where the nurses gathered the evidence, and that evidence was sent to the crime lab. And back in 1994 and 95, of course, our crime lab at that point was doing their ABO enzyme testing. It wasn't until the following year, I believe, or the year after that, they went to their RFLP. So we really didn't have much to go on. And, but that case was, as I say, back in 1994 and 95. What happened was that as the years, I think it was about 97 when our crime lab was really ramped up for RFLP, the police took all those cases back to the crime lab, resubmitted them and said, look at all these again. And what happened was that they did develop a nice RFLP profile, which allowed me to issue a John Doe warrant before the expiration of the statute, and this was our John Doe number 5. And I had a nice, at 6 genetic locations, RFLP, all those 5 incidents matched. So we knew we had a serial rapist in Milwaukee during that time frame. And I issued this warrant, this criminal complaint, along with the warrant on March 16th of 2000. Let me, will this go backwards? Yes. Okay. And as you can see, the first incident was, March 27th of 1994. And I issued my warrant for arrest, or the extradition order, and signed by the judge on March 16th of 2000, 11 days before the expiration of that statute of limitations. And that's basically how things stayed. As with our statute, again, there's so many parallels. When I have done so many cold cases and cold hits, the parallels really are remarkable, where there was a change in technology. So in 2001, our crime lab converts to STRs. So again, we want to send everything back to the crime lab and have it redone. And our post-conviction statute in Wisconsin also clearly states that if there is a better technology or other results were inconclusive, certainly that can be part of, a reason for allowing the post-conviction motion and for having the testing. And so what happened was that all the cases went back, reanalyzed, and a nice STR profile was developed. Again, we knew we had a serial rapist, but again, it confirmed the RFLP that this STR profile was the same from the semen from all 5 victims. And that just stayed that way for 7 years. And then in June, as you can see, in June 25th, these are just excerpts from our crime lab reports. We get a hit out of Endus, and it's in the Illinois Convicted Offender Data Bank. And we get that hit on June 25th of 2007. And when they did some checking, and by the time our crime lab and our people in the data banking get in touch, I think Illinois was in Springfield, I think that's where their data bank is, and get all the reports and everything together. It was late July, and I wanted to find out more about Mr. Washington, and he had been released. He was released in May of 2007. Then we get the hit in the data bank in June of 2007, so he was on the streets of Chicago. So with some help of some Cook County detectives and the U.S. Marshals, we were going down to Chicago to locate him, pick him up, and extradite him back to Wisconsin. But this was the first time. Up until this time, I had about 8 cold hits on my John Doe warrants, all of them sexual assaults, but the prisoners were always in Wisconsin. And that was no problem. I could just do an order to produce, bring them down to prison, file an amended criminal complaint, substituting the name of the prisoner for the genetic code. But this was a little different now. I didn't know how an Illinois magistrate would rule on our Wisconsin John Doe warrants. So it was fun to get a little bit creative. So I made my amended criminal complaint and naming Rodney Washington, formerly known as John Doe number 5, and further identified as all of the, just to, make it just clear to the magistrate in Illinois what we're doing here. Although I'm confident that the Illinois magistrate was very happy to take a serial rapist from Chicago and ship him to Milwaukee. I still wanted to cover all bases. So I had about an 11-page criminal complaint and went through everything and the changes to the STRs and the data banking, and ended up with quoting our case law in Wisconsin, our appellate court decisions, and also just running through the whole thing and laying it out for the magistrate. And there was no problem. And actually, Mr. Washington waived his extradition, was brought back to Wisconsin. But now I'm, getting ready for trial. And it's been now 14 years. 4 of the victims were 14, 15 years old at the time, just schoolgirls going to school with their backpacks on and dragged off the street to an alley or somewhere. And it just, a vaginal and oral assault to them. And the other victim was 20 years old. But you can imagine going back to them now and saying, well, we got the guy and we're going to get geared up for trial here. And there are these similarities, as Christine just before spoke about, the families of the innocent. It's the same thing for our victims. When we notify them, we are going to be reopening this case. This is tough for them and their family after so many years. But I've talked about the time limitations, where I think there's a parallel where we as prosecutors go after these cold cases and allowing the post-conviction to go forward. Most important thing is you got to find an investigator to commit to the case. And the same thing for post-conviction motion. Someone who's going to give an honest effort to look for that evidence and find it and really track it down. And that's important for me, too, as a prosecutor when I'm getting ready for a trial that's 14 years old. Locating that biological evidence is the same for us. Identifying all that discovery, the changes in technology. We've gone through those, as you can see in this case, from ABO enzymes to RFLP to STR and then to the data banking. And also identifying third parties. I want to exclude all the possible third parties before I get to trial. In the post-conviction phase, you want to look for third parties. You're hoping to find a profile, a different profile from the person you believe is innocent, and that profile points to someone else. So again, remarkable similarities, whether you're doing a cold case, prosecuting it, or you're looking at a post-conviction motion case. Finding all the discovery is very tedious. It's tough. You've got to get it together. I've got to read and know all about those ABO enzyme results. I want to know about the RFLP. I want to know about STRs. I want to read every report, and so would you. So would anyone else on a post-conviction motion. You have to look at those. They give you all sorts of great information about this case, where it's been, and what was tested and what wasn't tested. Very important. You have to put it all together. One of the reasons I like John Doe warrants over the legislative changes is because it forces me as a prosecutor to get that case before the statute expires and put it all together. And back in 2000, before I issued the John Doe warrant, I had all of this done, knowing that someday we would get a hit out of the data bank, and 7 years later, I don't know if I could have accomplished getting all this if I had let the 7 years pass and not go after it. So all of that was put together, and we're in pretty good shape. Again, you have to read all the ABO enzyme. One of the things, too, we have a serial rapist who is operating in Milwaukee in 94 and 95. And you know from experience, the police are picking up people, getting blood samples from them back then. Their anonymous tips come in. They go on the news looking for it, and flyers are sent out. And a lot of people are brought in, and their samples taken to the crime lab. you have to exclude all those people, and that's what I want to do, so that I can prevent the defense from going down those, what I believe are blind alleys, but preventing these third-party defenses from going forward. But also remember, you're going to be you've used quite a bit of sample on these scenes with ABO. Again, third-party defenses, I like to cut the defense off at the knees with all of these, and I go after all these and have my investigator clear this up for me, and then bring my motion to eliminate, not to that this on relevancy and probative value. We're not going to go down the road on these third-party defenses. But you're also looking for, what you're looking for is that third party in the post-conviction motion that's going to point to someone else other than your client, and that's what you're looking for. I'm doing it to keep it out, not to confuse the jury, and to have a nice trial. But that's what happens, and you've got your old RFLP reports. You have to go through those. And here's a point that is so I found over the years, whether I'm working on a post-conviction case, looking for evidence, the success that we have had with these DNA return packets. One thing when you're looking for evidence and you're told it's destroyed, just be aware that when the crime lab finishes up, they take all their little extraction tubes and they put them into these envelopes. I think Major Whitman spoke of this yesterday, and send it back. Depending on who may get that at the evidence room, may not know what to do with it. And as we found at one point, a whole bunch of these return packets in a box. They now get married up to the case, but they may not get married up to the right inventory number. So you really have to search, whether this is post-conviction or I'm getting ready for trial. You've got to really search, because stuff gets lost, it gets misplaced, and just put in different locations. But the return packets are important, and it's something to look for. And when I sent them out, those return packets, back to the crime lab, and I did that in August of 2007. And you may wonder, why did I send that one out? And what they did is, I wanted a profile, and they used the extraction tubes from one of the sexual assault cases. The reason being is that changed when we had all of our STR profiles on the evidence. They used profiler, co-filer. When we finally brought Mr. Washington back from Illinois, our crime lab was using PowerPlex 16. And again, knowing the defense bar, I wanted one of those evidence samples to also be tested with PowerPlex 16, so that no one could get up and say, where are the pentas? Did you test, my client had these pentas, did you test the evidence for pentas? I'm kind of a crazy man. Thank God I'm blessed with a wonderful crime lab that's very cooperative and very helpful and will do these things for me. But it is important to cut that out. I wanted to have the pentas on one of the evidentiary samples, and that was gotten from the extraction tube. And there are a number of cases that I've been involved in. Those extraction tubes, from what the analysts tell me, they just put a little TE in it, I think it is, at the buffer, heat it up, quant it, and off you go and run it, and a lot of great success. And I'm just going to end with, there's one thing that we also all agree on, is just what you're doing, especially in the sexual assault cases. You're reopening some tough stuff for these victims. And I have down there, will she show up for trial? For my trial against Mr. Washington, I was 4 for 5. One of the victims, she just couldn't go there. She kept saying yes, 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 but the day of trial, nowhere to be found, no answering the cell phone, no. And later on, talking to her, just couldn't do it. Could not go there again, could not relive that case, and it's understandable. It's understandable. But Mr. Washington was convicted of numerous counts of sexual assault and received 100 years in our Wisconsin State Prison. So thank you for your very kind attention.
Good morning. I asked to follow Norman Gahn because I thought the most important lesson, not that he doesn't have many, is that cold cases, old cases, can be tried and can be tried quite well. And the reason I begin with that comment is that I get concerned when there may be a background concern for some folks opposing post-conviction DNA testing, that we're going to be opening up this whole ball of wax. And now we're going to have to go back and try a case. Well, Career prosecutors like Norm Gahn have made an art of this and have shown that it can be done. And in one way, somebody who's opening a cold case, because that's what exonerations are, there are other forms of cold, old cases, is going to have an advantage. There will have been trial number one, so if you can't find the victim, you're going to have recorded testimony. But having said that, I want to go to some lessons from the cold cases that have proved to be, that are the exoneration cases. And just want to walk through this briefly. We know this now, that when we look at a request for DNA testing on an old case, please don't start by saying, don't do it, we don't need to do it because there was corroborative evidence. What should be crystal clear from the presentations and all the research is cold cases that are exonerations have all of these, yet we know the wrong person was adjudicated. I take you back to a U.S. Supreme Court case, the first case decided, written by Justice Alito, writing unanimously for the United States Supreme Court in 2006, the Holmes case. And I'm the first to say Holmes is a trial evidence standard, not a post-conviction one. But the court got it there when they said, look, when we talk about should defense evidence have been admitted, don't say, well, gee, there was a lot of prosecution evidence. Take a look at the defense evidence and say, does it make some sense? Could it have an impact? It's not the post-conviction standard, but it is a recognition that there could be strong prosecution evidence, but also strong defense evidence. And that's something that courts have started to accept in the post-conviction arena. And again, you've heard these PowerPoints will be made available to you within a week or so. This is a New Jersey case saying, should we have post-conviction testing? And they got it. They said, don't ask how much prosecution evidence there is. Let's take a look at the strength of the DNA. This is a quote from an Illinois case. They said, you don't have to overcome how much government evidence there is. So this is folks starting to get it right. I think we all have to take a step back. We've heard a lot about science and the great benefits of science. We're learning more every day about behavioral science. This is from a recent study. We can all talk about staged crime studies. They're good, they're not so good. But they did a study and showed people a lineup, and some of them picked person A. After they were told, by the way, person B confessed, they reassessed their lineup identification and said, I'm sure it's B. And that's merely there to say the human mind is not perfect, and we have to understand, and science helps to show us that those types of influences can be there. We've heard about tunnel vision. And boy, defense attorneys, I've done it, tunnel vision. We all have to take a step back and recognize that that is a phenomenon that inhibits reliability. There's a wonderful article about it. Is Keith Finley here? Are you here? You are here. Isn't that your article? Yeah, that's his article. All right, Keith Finley's a wonderful scholar who's done a lot of work about this, and he wrote about it, and it reminds us it afflicts all sides. And it's so something that we have to take a step back from and say, let's take a fresh look. Well, maybe there's another issue. I need you to know that in 12 of the DNA cases, the exoneration cases, at trial, the jury was told it's not this defendant's DNA. In other words, they actually had DNA, they excluded this defendant, but had a theory that he could be guilty anyway. It was only later when they ran the DNA through ENDIS and got a hit, like the hit in Norm's case of somebody who'd been doing this elsewhere, that they said, our whole theory was wrong. And again, I put this up there merely to say, we can all get seduced by grabbing onto a theory a little bit too early. It's called keep investigating. And of course, it raises a question, who is this new person? Is he definitely the perpetrator? Is he more likely? Where is this at? It's going to depend on where that DNA evidence was, where the biological evidence was, but it's the point, keep investigating. Well, here's another one. Please don't say when you're evaluating, should we have post-conviction DNA testing? Well, the thing was kosher. I know that's not a word that the Supreme Court usually uses, but you know what I mean. Okay, that, you know, the motion to suppress was heard. Well, please take a look at this. 158 of the first 200 cases involved eyewitness. 29 raised constitutional claims on appeal. Something was wrong with our identification process. On all 29, the appellate court said nothing was wrong. Now, they may have been right applying the legal standard, and that's a whole issue for another day. My point here is we can't use that as a criterion for saying, well, you had a motion to suppress, therefore don't do post-conviction DNA testing. How about, well, there was a confession, we've heard a lot about this, but again, in terms of a legal review of the confessions, courts looked at them, said, this seemed to meet the Miranda standard and the voluntariness standard. It was okay. That didn't prevent people from being wrongfully convicted. Criminal record. Well, the guy has a criminal record. He's done stuff like this before. Should not be the standard. In 80% of the DNA exoneration cases, more than half of the exonerees had prior convictions. Now, this slide comes from a study that suggests maybe there are problems with Rule 609, that a lot of these defendants didn't testify because their lawyers rightly told them, you'd better not testify because your priors will come in. But I think it has a different significance, which is we can't look and say, don't test because he's a bad guy. He's done stuff, even stuff like this, before. Yet we have a disconnect in some areas of the country, and I'll start with my home state. This was from our Superior Court. The guy confessed. So you don't get testing. And I want to echo here a comment I made yesterday. Please distinguish between the decision to test and then the decision to grant relief. To me, they're two different issues. But we should be very, I'm always afraid to use this word, liberal, okay? Very open in terms of the, at least let's test, and if it's not this defendant, let's do the second test, which is check the database. This is a Tennessee case. If the guy's only arguing recently for DNA testing, and he confessed, don't give the test. So I suggest that's part of the disconnect. This is from a very recent case. How can you let somebody who pled guilty ask for the right to present new evidence? This is Indiana, 2008. And they said, gee, his confession and his new claims both can't be true. Well, that's true. Now, this was not a DNA case, but this was a court saying, you're stuck with where you were. And I'm simply suggesting that science and experience tell us otherwise. And this was one, just, I don't have a report on this one, this I saw on a listserv. A trial court says, we're not going to give DNA testing because there was really good blood spatter evidence. And I'm suggesting that a lot of this is, as I call it, a disconnect. Oh, he pled guilty. Well, please be aware that 9 of the exonerees pled guilty. Many more did not dispute identity at trial. That's a disconnect in terms of evaluating whether it's appropriate to go to step 1 and do the test. Now, please, I don't pretend to be expert on this, and I hope this will be some of the discussion in this afternoon's breakout. But what this has made me think is that when people are going to ask, I've got this petition, whether I'm a defense lawyer being asked to file the petition, or hopefully a prosecutor is being asked to take a position on post-conviction testing. My attitude is take a step back. If all these slides have shown make any sense, it's forget there's a confession, forget there are 3 eyewitnesses. Could this piece of biological evidence, if it's not this guy's DNA, have some meaning? And if you start there, and the answer is yes, then test. As I wrote, the decision to test is not the same as, okay, we're going to go ahead and let this person out. I mean, all my clients are in jail. All these people we're talking about in jail. To give a test is not endangering public safety. I wanted to remind folks here, what's the converse? Well, back in the days when the defense was fighting DNA, the California Supreme Court said DNA is so good, it should come in and be enough to convict when the eyewitness picks somebody else or gives a bad description, something that doesn't match. Well, it's sort of sauce for the goose, sauce for the gander. Now, collateral lessons, because I was asked to talk about this briefly. I am the strangest bedfellow of Mitch Morrissey, but I'm a big fan of familial DNA because of Darrell Hunt. And all I'm going to suggest is when we talk about cold cases and lessons from DNA, we as a community have to grapple with issues like that. I think the real issue is the databasing issues that come out of it. When you gather the 5 family members' DNA and 4 of them aren't the guy, let's have some privacy concerns. But we can't ignore the power of familial DNA. Collateral lessons. Norm Gahn explained to us the tremendous power with DNA to expand statutes of limitations. Well, maybe we have to have that same approach for post-conviction statute of limitations. Defense access to CODIS. We heard about that. Please consider the case of Jeffrey Deskovic. At his trial, they knew it wasn't his DNA, but nobody took the next step and ran the DNA. And maybe back at that time it wouldn't have hit, but 16 years later, because of the credibility of the Innocence Project saying, would you do that? They did it, and they found the real person. Jeffrey was a guy who had confessed. And so we have this legal issue, and Dave Rudofsky talked about it yesterday. Is this a Brady issue? Should it be? Please aware right now it's 2 states that allow post-conviction defense access to CODIS. Here's another one. We all know, some of us happier than others, that the National Academy of Sciences report is on the way. Lord knows what it's going to say. Is one of the collateral lessons that we have to at least start talking about is just as we have statutes for post-conviction DNA testing, will we have to ask the question, should there be such statutes for non-DNA post-conviction forensic reevaluations? So, I'm the law professor. I like to give takeaways, not exams, but things you can take away and make use of. I'm just going to tell you at the end of this, and this PowerPoint will be available to you online, are a number of resources. One is a new article by Keith Finley, and what he's really saying there is we shouldn't be at loggerheads, that the model you either had criminal law as a crime control model or criminal law as a defendant due process model actually merges quite happily when you get to a best practices model. So that's just something worth thinking about. His tunnel vision article I talked about, John Bloom's article is about the criminal record histories of people who've been convicted wrongly. Brandon Garrett's written 2 articles on post-conviction issues and innocence, and the Claiming Innocence article there, one talks about all the different statutes nationally and the DNA post-conviction statutes and sort of the ebbs and flows of the decisional law. Brandon Garrett has another article. Michael Reisinger has an article trying to grapple with that question. Can we tell if there is a wrongful conviction rate? There's this guy Epstein who writes about familial DNA. It's a brilliant article, I might add, and it's available. Sam Gross has a new article also talking about this. And two real important cases. The Bell case, of course, is the United States Supreme Court really starting to grapple with DNA. It made the court look a little bit differently at habeas, but maybe it's a lesson all of us to reread and say, DNA is pretty powerful stuff. United States versus Risha is just an interesting Brady case because it talks about when different law enforcement agencies cooperate, how far does the Brady obligation extend? And maybe that's the beginning of the inquiry as to whether CODIS and ENDIS and this whole system makes the Brady obligation extend there as well. So I have to thank NIJ for inviting me, primarily because you made my wife very happy by having this here. And thank you all for listening to me.
Good morning, everybody. I'm happy to be here because of this nice, relatively nice weather, too. I'm from Washington, D.C., where it was pretty darn cold for the inauguration last week. But regardless of your politics, I think you really have to agree that the warmth of the spirits and the profound effect of the international support for this country and for our new president was just overwhelming. And I'm looking forward to a real focus on issues of justice and social justice in the coming administration. So it's my political ad. I'm the director of the National Center for Victims of Crime. And at the National Center, we've learned quite a bit about the impact on victims when we prosecute cold cases, when we revive cold cases, or when you have post-conviction litigation involving DNA or whatever else. We learn it by coming to meetings like this, reading and so on, but I really want to share more of what we learn directly from victims and hearing the voices of victims who call our toll-free helpline every day, over 30,000 calls a year. And that phone number is 1-800-FYI-CALL, and I give you that number because everybody in this room works directly with victims, or your work indirectly affects victims. And you may run across some who don't know where to turn, don't have anybody to talk to, need information, and they can call us. Anyway, I want to share a phone call that we got about a year and a half ago, and it's the adult child of a homicide victim who called our helpline, and this was in the context of an exoneration. She called the helpline, and she was crying almost hysterically, and all she could say was, "They're letting him go. They're letting him go. Now what should I do?" And we talked more with her, and it turned out that this caller's mother had been murdered decades ago when this caller was just a child. And this man had been convicted of that murder and was serving a long sentence. And it took many, many years, but the family members felt as if they finally had put their lives back together and had moved forward and had gotten as much closure as you can ever possibly expect to get in a situation like that. And now she was just stunned to learn that the person who had been convicted of this crime had been released after decades behind bars. And just as legitimate as the pain and the wrongfulness of that wrongful imprisonment, conviction and imprisonment, were the anguish and the unanswered questions of that caller. Are they going to find the person who really did it? Are they even looking? Why is my family going through this? And why is my mother's memory being trashed like this? I can't deal with this. I can't relive this, and yet I can't escape it. And why, in God's name, did I have to find out about this through the media? And shockingly enough, that does happen. And there are plenty of people who could share the blame for that. But there are many, many victims who are not getting the kind of information and sensitive treatment that they need. So when you take the time to consider the impact on victims of reopening old cases, either through a cold case hit or an exoneration, and even for very legitimate reasons, you will often find victims who will tell you that it's kind of like an old wound, like a scar that has just barely scabbed over, a wound that has barely scabbed over, and then I feel it's just being ripped off and all that raw pain again. And I don't think there's anything I could say to you that would express it as eloquently as what Jennifer said to us yesterday. That was very moving, and I'm grateful to her for sharing her experience with us. You know, research tells us that anytime a victim participates in the criminal justice process, chances are pretty good that the victim's original trauma will be exacerbated through that process. Try as you might, and I was a prosecutor for many years. I tried to minimize that trauma, but I knew, when I looked in that victim's eyes, I knew that it was incredibly painful. So you do the best you can, and I know that you all do the best that you can. You know, we know what that phrase, being re-victimized by the process, means. It means being disbelieved. It means being cross-examined, sometimes in very brutal ways. It means being left out of the process, which is really what victims very often experience. They are oftentimes a piece of evidence, just like the test results or the hat that was found at the scene. They're treated like a piece of evidence. And unfortunately, in the post-conviction context, they are often treated the same way. So I'm saying this not to beat you over the head with the victim's trauma, and certainly not to minimize the gross injustice of spending time in prison for a crime not committed by the incarcerated person. But I just want to call to your mind the reality of what a victim experiences. So bearing that in mind, I just want to make some suggestions to you about ways that we all can work, and it's so important for us to work together to minimize the trauma and the pain, the inevitable pain of reopening old wounds through a cold hit or a post-conviction exoneration. I think one of the most important questions we have to ask ourselves is, what about notification to the victim? Who should do it? When should it be done? How should it be done? And perhaps most importantly, then what? And you heard Jennifer say yesterday, these folks didn't just drop a bomb and walk out of the room on me. So that question of then what is also really critically important. When do you notify the victim? If you are involved in an exoneration situation where you're investigating post-conviction, I must say I really applaud the Innocence Project for their policy of not going to the victims. It's very important that you have people who are trained in dealing with victims, who will hopefully understand this individual victim. And anybody who is approaching a victim in this context, and it's terrific if you have a good relationship with the victim in the first place. You know, if even a case that occurred many, many years ago, the detective might still be around, and thank my God, if we're so fortunate to have a detective like Detective Abel, who worked with Jennifer, that person should definitely be involved, and a victim advocate. Great if you have the one who was originally involved, but you need an advocate. You really, honestly do. And take into consideration the victim's individual circumstances, their fragility, what do you know about their mental health, about their family situation, and so on. Take all of that into consideration and make a considered judgment. I personally don't believe that there's a flat rule about when to notify and who should notify. I think these things all have to be considered on an individual basis. And some victims, for instance, should be told as quickly as possible, as soon as possible. And some, in the exoneration, the post-conviction context, for instance, maybe it's not such a good idea to notify when you get a request from someone who's incarcerated for DNA testing, because perhaps nothing will come of it. It's all, you have to really think about this on a case-by-case basis. But anyway, you know, I want to tell you one little story about this. Think about it and be careful. A friend who runs a post-conviction witness assistance unit got a case, and there was a cold hit, a DNA hit in a cold case, and so got the detective together, and it had been many years, and they thought this victim is going to be so happy. And many victims are happy to hear that finally the person they've been dreaming about, as Jennifer described all these years, has been found, and then they can expect justice. But don't be surprised, because that's not always the response. This guy took the detective, and they went to the victim's apartment, and they knocked on the door. They said, "We're here to talk to you about the case." The victim stepped outside, slammed the door, and said, "Come with me," and walked down the street with them. Well, it turns out that this victim had been raped 15 years before. Inside the apartment was her son, who was the product of that rape, and he did not know that, and her husband, who also knew nothing about this rape. And many victims keep that information private, and they move on, they create a whole new life, and they don't ever want to go there again, and they don't even want to share it with their loved ones. Keep that in mind. That's a real possibility. And there are all kinds of circumstances in people's lives that change over time. Think about that before you approach a victim, and find out as much as you can. So when to notify the victim, definitely it's a case-by-case situation. People will say information is power. You need to give that power to the victim right away, but be thoughtful about the way you do it. Who should do it? A trained person. Take a victim advocate with you. And we heard from Mr. Cox yesterday, the prosecutor from Baltimore, who said, "Oh my God, I am so sorry I went to visit that 67-year-old woman by myself because I couldn't handle it." And reading between the lines, he said, I didn't do as good a job for her as I wanted to be able to do. I needed an advocate with me." So do that. And how to notify the victim. Again, that's a situation where you need to think about the individual circumstances. In general, it's best to do it in person, because you can see the victim's face, you can better gauge the reaction, and you can, and I highly recommend this, give the victim some information, resources, and so on, so that when you walk out that door, the victim will be stunned in any event. She or he will have an opportunity at a later point in time to process this. It takes time. You can't just expect people to cope with this and process it. It takes time. So bring them some information. We actually, at the National Center, produced 3 brochures, which are on the table out there. And one is DNA in crime victims, what victims need to know. And this explains in very simple terms what DNA and DNA testing is all about. DNA in crime victims, this is information for victim service professionals, which frankly all of us could use. And then there's one that gives police some advice on notifying victims in cold cases. But whatever resources you use, bring them something. They need to know, what is this thing called DNA? What does it mean for me? What does it mean for this case? What does it mean for this defendant? How do I explain this to my family? Am I really going to have to go to trial now after all these years? And what impact will the DNA have on that, on the trial? So please give the victim as much information as you can in a very, very sensitive way. And finally, be absolutely sure that that victim has access to resources. Not all victims will use it, and we heard from Jennifer yesterday that she just wanted to be able to talk to the detective and that was good enough for her. And later on, she told me that one reason that worked well for her was that this detective was incredibly sensitive and he took her concerns very, very seriously. He never minimized her anxiety. That's an extraordinary individual. But make sure that they have resources. Check and see if victims' compensation in your state, in a case where you have post-conviction litigation or even in a cold hit many years later, will victims' compensation provide any resources? Will they pay for counseling? Find out and know the answer before you go and notify the victim. Make a connection with a local victim service provider, and you can call 1-800-FYI-CALL if you don't know who the providers are in your community, because we have a data bank of 15,000 service providers around the country. We'll connect you with some organization that will be able to provide this victim with some resources. But please don't go there unarmed, so to speak, with information and resources for that victim. I applaud you for all the work that you do, and I'm really appreciative of the opportunity to speak about the victims' concerns, because they are the other major party in any criminal case. And just as we all know from the stories we've heard over the last couple days about the defendants and the exonerees, victimization, too, is a kind of a lifetime experience. People don't just get over it. And it's up to us to help them with that and to give them what they need to rebuild their own lives. So thank you.
We started a bit late, and so we want to make sure that as you line up for questions to the panel and discussion, they really welcome that. So if we could go ahead and take those questions. And while you're doing that, I was asked to make a couple comments from the law enforcement perspective. First is that we really need, as law enforcement executives, your support in making the changes in a police department or a sheriff's department that are necessary to provide the resources, whether it's in evidence storage or in support of the crime lab, or whether it's in victim advocacy or victim assistance. Also, changing the culture of a police department, as one academic who studied police departments likened it to bending granite. And so, and that may be actually easier, but this Christmas I was given an entire season of The Wire. I had never seen one segment of The Wire. My wife is a criminal justice researcher. We have become addicted to this, and we could sit there and watch 4 one-hour sessions in one evening, staying up way past our bedtime. But the major in charge of the Baltimore Homicide Squad has one thing every day in every segment in this first season, and that is, what is the clearance rate? How many homicides have we closed? What's our clearance rate? That's what the mayor wants to know. That's what the Baltimore Sun wants to know, on and on. We need the kind of support so that our detectives are not just evaluated based upon their clearance rate. We need the kind of support where detectives actually would get an award from the department for working as hard to get the wrong person out of jail, hopefully shortly after arrest and not after conviction, but they would get a recognition and award for that as much as for solving a true mystery. So these things are important, and we appreciate the partnership, and I think that has been echoed throughout the presentations here yesterday and throughout the day today. Please direct your questions to any member of the panel.
I have a comment, actually. My name is Eva Marie Lewis. I'm the DNA Forensic Science Supervisor at the Wisconsin State Crime Laboratory. And earlier, Norm Gahn openly complimented the Wisconsin State Crime Laboratory in Milwaukee. And in kind, I wanted to openly thank him for that, and also affirm that for which we have been doing, we will continue to do in working with our submitting agencies in putting forth good quality crime lab case completion and following through with the expertise associated with those cases. Thank you.
My name's Connie Milton. I'm also a crime lab supervisor in San Diego, California, and I just wanted to clarify something that, Jules, you mentioned and is also in our little handout here, and that is about the CODIS and ENDIS rules about what's eligible to go into CODIS, and how it says here that there's only 2 states that expressly permit the entry of crime scene evidence, and I just want to clarify what the CODIS and ENDIS rules are. And that's a DNA profile developed that is submitted into CODIS must be reasonably assumed to be from the perpetrator of a crime, and that profile needs to be generated or approved by an accredited government laboratory. So while many states do not expressly say that, if that DNA profile meets those ENDIS rules, it can go into CODIS.
I hope I'm on. Thank you for the clarification. My point was when the defense has the right to demand, so to speak, that it be pushed in. And so you're absolutely right, and it also varies from state to state. It may be into the state databases first, but a fair point. Thank you.
Hi, I'm Sergeant Brady. I have the Special Victims Unit in Baltimore County Police in Maryland. And I guess for the last 3 years, we've cleared 54 CODIS cases going back 30 years and actually made arrests on all those. But the reason I came up here is because, Mary Lou, we were totally shocked when we were contacting victims from 30 years ago. Some of them are in their 70s, and we had all kinds of responses. It was all over the charts. So in our department, we have a collaboration with, it's a group that we have. It's us, and it's a prosecutor, victim witness, and our safe nurse. And I came to them after like the first year of this and said, we got problems, because there were plenty of people to go to for current rapes, because I have, we do all those investigations, but what do you do with someone that's, 30 years ago, we knock on their door, and we have all these different responses. So we actually, with the team, developed a brochure. And it's interesting because the title of the brochure is Cold Case, Time May Not Heal All Wounds. And it is. I mean, we're talking to these people, and you think that it just happened, and we felt awful about that part, but we felt good because we were making an arrest. But then we had to tell them, you may have to go to court. So it's just basically like dealing with the victim where it just happened. So they're faxing it to me, so if anybody's interested. And the other part we had with this, our victims are all over the country, and one's in New Zealand. So we had to make sure in this brochure, we put a number in there and a website, so no matter where they live, they can still get help. So just thought I'd throw that out.
Well, thank you so much. I'd love to see your brochure. And you can also use our database if you're looking to find a victim service provider someplace else. Victims have they've oftentimes relocated, and there's nothing like a reality check to truly understand that victims have all kinds of different responses to this, and you got to be prepared, and you better have somebody with you who understands how to deal with those reactions and how to help that victim.
My question is for Professor Epstein. I'm Roger Kahn, the Forensic Biology Director for the Harris County Medical Examiner's Office of Big DNA Lab. I just didn't understand what you said when you said 2 states allow defense access to CODIS. That's all. I'm not going to guess. Just curious.
In terms of post-conviction proceedings, 2 states apparently have legislation that allow the defendant to go to court and say, for example, they did this test, it's not my client's DNA, there's this profile, I want it uploaded because maybe it will lead to third-party evidence. That's what I was trying to express. You're like many of my students, they also don't understand a word I say. So, but I hope I did it better there.
No, I understood everything. I'm just, no, wait a minute. Just so that the discussion can continue and make some sense of this, everything we do goes in. So I'm trying to think of a circumstance where it wouldn't, and the 2 states came to the rescue with legislation to fix that. Now, the only caveat is it has, well, I guess 2 caveats. It has to be eligible, and there are rules that you just heard about, you know, it has to be clearly from a perpetrator. It can't be, well, maybe it was the victim or the husband, you know. That kind of stuff isn't allowed in CODIS for real good reasons that we all get. And the other is if the laboratory that produced the profile isn't accredited.
Okay. My understanding is maybe not in terms of, I hope the correct phrase is a keyboard search. It's another, am I right there?
I think that's
Right. In other words, the defense gets a report back, we've done post-conviction testing, or like in the case of the guy Jeffrey, 16 years ago, we already knew it was such and such a profile, not this defendant's. And the defense is saying, well, will somebody check that against the database? There is not a mandate nationally that that be done at a defendant's initiative or request. Some would argue that's part of the Brady versus Maryland, is there a due process right? 2 states have said, if the defense comes to court and makes that kind of a showing, we'll order that it be done.
Wow. I can't see why anyone would object. I mean, it just seems, you know, if you've got a meaningful profile and it's eligible, why would anyone want to keep it out? I mean, that's the whole point of the thing, right? So the only other thing is if it's not an accredited lab, and some aren't, and, you know, it's a debate for another day, but do you want to make sure that the data that's in there is data from a laboratory you have some relationship, you audit, you check, you're confident in? So I think that's just a moment on the rationale for the accrediting requirement. But other than that, who could disagree with that?
I hope that's the sentiment. Thank you.